A court in Georgia has decided that extended stay hotels are actually landlords and that tenants in these hotels have eviction protections. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have an interesting article for you today, and it's coming out of Atlanta, Georgia. Okay, and so they have this issue here. They had this court case where tenants of these extended stay hotels, they were saying that they were illegally evicted because they were actually not in a hotel relationship with these hotels, right? They actually were landlord-tenant relationship, and that they deserve the same eviction protections as any other tenant, right? Now, I just read about this, so I'm not 100% on the details. That's why I'm going to be going over the article. So, it really sounds like an interesting case, and I wonder what the implications could be for extended stay hotels throughout the entire state. Now, before I get into the article, go ahead, hit the like and subscribe button. Maybe leave a comment down below. Let me know what you think. Do you think that extended stay hotels, tenants in these hotels should be able to get the same eviction protections as a tenant in a long-term rental? I know I don't, okay? I maybe there's more details in the story that kind of clarify why exactly the court believes this is the case. And I know that Georgia is not a anti-landlord place, right? And it's not a very left-leaning place. It's known to be a very conservative place. But, there has to be some kind of logic, and hopefully they wrote it into this story that says why they made this sort of decision. So this article is coming from AtlantaCivicCircle.org, and it says, court decides extended stay hotel guests are legal residents with eviction protections. All right, let's get into it. People living at extended stay hotels won protection from informal on-the-spot eviction this week when the Georgia Court of Appeals ruled they should legally be recognized as residents, not guests, and thus are covered by landlord-tenant law. The March 7th decision found that Efficiency Lodge in South DeKalb County illegally kicked out 3 tenants in 2020 who had fallen behind on rent because the hotel was actually their landlord, as first reported by the Atlanta Journal-Constitution. So it sounds like these people, they were staying in this extended stay hotel. They were behind on the money that they owed so that they could continue to stay there. And because it's a hotel and not a long-term landlord-tenant situation, they could immediately just basically just lock the door and get the heck out. So I mean, that to me, I have no problems with it, right? But for some reason, this court is saying, no, these people were tenants. They have to go through eviction court. They have to go through the eviction process, etc. And I'm like, well, yeah, but it's a hotel. You're the way. I mean, I've stayed in an extended stay hotel for a couple of weeks when I first moved up to Omaha before I found my first place to rent long term, and there were people living in there who my guess is that they are the people who are the very bottom rung of society, and this is the most that they can have, and had a little kitchenette in there, and I don't know how long term most of those people were staying in there, but it's an interesting type of situation to live in. It was even so bad that the school bus for the area where I was at actually came to the hotel and picked up kids to take them to school. So, it was I'm assuming that a lot of the people who were staying in that hotel were staying pretty long term. Now, maybe that's part of the reason, but let's continue. Atlanta Legal Aid Society attorney Lindsay Siegel, who represented the former tenants, told Atlanta Civic Circle that as rent and home prices spike, extended stay hotels offer much needed housing for low-income people. Consequently, the ruling has far-reaching implications. This ruling is not just about Efficiency Lodge, Siegel said, adding that there are nearly 26,000 extended stay units in the 5-county metro Atlanta area alone. It applies to all extended stay hotels in Georgia. These are businesses that profit by renting permanent and semi-permanent housing to the lowest income families. Siegel successfully argued that her clients and other tenants make extended stay hotels their permanent homes by moving in their belongings, receiving mail, and having their kids picked up by the school bus, among other actions. I mean, that's a pretty good argument, in my opinion. You know, if they're getting mail there, you know, they're having their kids picked up. You know, I told you I saw that myself, and they've got having personal belongings there doesn't really mean much, because most of these they're fully furnished. Okay, most of the units, they're fully furnished. You know, they have the bed, they have the little kitchenette, and they have, you know, maybe a couple of chairs, a desk in it, etc. Like, you know, they are an extended stay hotel. So the point where they're getting mail there, I mean, you can get mail at any hotel. That's not really a big deal either. But the one thing I would say, the school bus issue, you know, where you have the school coming in to pick up your kids from the hotel, that makes it seem like it's a more permanent type of housing right there. Okay, now here's my question: at what point, though, does the tenant become a permanent resident? Okay, is it after a week? Is it after 2 weeks? Is it after a month? I mean, it needs to be defined in law. And if I was the hotel owner, you know what I would do? At that point, I would just instantly kick everybody out. You know, just be like, hey, you can't stay. You know, like if they say, well, if you're there for longer than a month, then you're a permanent resident, I would kick everybody out after a month. Like, no, you cannot stay, at least in this room, for longer than that, right? You can come in, you can, you know, stay at the extended stay for up to 30 days, then you're instantly kicked out, and the only way you can come back is if you move to another room, you know. And if they say, well, if you get mail there, then I would say, well, okay, well, nobody can get mail here anymore. Go get a P.O. box, you know, that's not my problem. If they say, you know, it's the school bus picking kids up, I'd be like, hey, well, no, school bus, you can't have your kids picked up from my hotel anymore. So basically, they are creating a new situation where the hotel owners and operators, they are going to have to operate by these new sets of rules that are going to hurt the people who are living in their units more than them. They'll still get paid, but they don't have to deal with all this nonsense, and they have to follow these rules so that they don't end up in this trap anymore. Okay, and that's what the only thing they can do, and that's the smart thing to do. Efficiency Lodge's legal team, led by former Georgia Governor Roy Barnes, whose brother Ray Barnes owns the hotel chain, had argued that its renters entered into an innkeeper-guest agreement, making them ineligible for formal tenant protections. But Siegel pointed to a Georgia law that requires innkeepers to pay a hotel occupancy tax only for stays shorter than 90 days. Her clients had resided at Efficiency Lodge for far longer. So yeah, it sounds like you have to pay a hotel occupancy tax for up to 90 days. So there's the solution right there. At 90 days, everybody gets kicked out. Nobody can have any sort of tenancy in your hotel for longer than 90 days. You're in a hotel innkeeper to guest agreement. You're not in a landlord-tenant agreement that way. And the state gets all of their hotel tax money. So that means that costs are going to go up for the hotel guests. That means that the hotel guests are going to have to move around more. They're not going to be able to, just stay in a place indefinitely. So yeah, this doesn't hurt the hotel owners nearly as much as it's going to hurt the guests or the tenants or whatever they want to call it. If they think that all of a sudden all of these hotel owners are going to be like, oh, yep, now we are essentially just a giant apartment complex, then they are just dead wrong. Okay, they are not in the apartment complex business. They are in the hotel business, and they're going to keep it that way by just basically following these new rules. So yeah, interesting situation they kind of created here, and I just don't know if I agree with the courts, though. It still seems kind of like these hotels were never meant to be permanent housing. They never were. Even though the tenants do stay for a long period of time, that doesn't mean that, hey, this is where they live permanently. That's why a lot of them, they require payment on a weekly basis, okay? Because simply put, you can only pay for 1 week at a time, and that makes it so that, you're not a true tenant that is paying, month to month, and you're not even signing a contract that says, hey, I have a 1-year lease or any of that. It's questionable. That's why I say, put in the comments what your opinion is of this situation down below, because I'm really curious to see what other landlords, what other real estate investors think of this sort of thing. And I hope nothing like this happens up in where I'm from. I know, like I said, I've seen something very similar with extended stay hotels in this area as well.